And we're recording.
All right, thank you, Dag. Good morning, everyone. Welcome to this meeting of the Subcommittee on Effectiveness of the Ad Hoc Commission on the Discipline System. We'll begin by taking the roll. Oh, by the way, I'm Sean Saleg. I'm chair of the Board of Trustees and a member of this committee. Ed Lear is the chair of this subcommittee, but he couldn't make it today. So I'm standing in for him as chair. And with that, let's go ahead and take the roll, please.
Okay. Karen Bell.
Present.
Ruben Duran.
Present.
Gary Farwell.
Here.
Jenna Jones. Is Jenna Jones here? Okay.
Can see her.
Yes, she raised her. She's
There I
muted.
am, sorry.
Thank you. Edward Lear, not here. Cynthia Nakau.
Here.
Alexia Mayorga.
Here.
Steve Moed.
Here.
Ellen Pansky.
Here.
Eloise Rosenblatt.
Here.
Linda Schneider.
Here.
Sean Saleg.
Here.
Brandon Stallings.
Here.
Judge Pong Wang.
Good morning. Here.
Okay, everyone's here except for Mr. Lear. You have a quorum.
Very good. Thanks to everyone for attending. We'll begin with a call for public comment. If there's any member of the public who would like to address the subcommittee, please use the raise hand function in Zoom to bring yourself to our attention. I'm not seeing anyone raising a hand, so we'll move on to our agenda, beginning with the chair's welcome. Welcome. So Leah will provide most of the content for this. I will just kick it off by saying, in the big picture, what we're going to do today is, in terms of getting action items done, is look at our charter again to focus ourselves on our mission. And we're going to, after some presentations, be deciding what topics we want to focus on initially. At our first meeting of the full commission, we came up with a very lengthy list of things to study. And so now we need to hone them a bit to start figuring out where we're going to focus our initial work. And with that, Leah will have more to say about this. So I'll turn it over to her.
Okay, great. Lisa, do you have ready to put up the charter?
Yes.
Okay, great. So just kind of following up on what Sean said, I thought it would be helpful for us to take a look again at the charter of the commission. And with that in mind, think about what we hope to accomplish with this first meeting and then with our subsequent meetings. So the part I think is really important is the section that begins with, in particular, this body, being the commission, will review the full catalog of reforms the Office of the Chief Trial Counsel has implemented and identify one or more to focus on. So at the first meeting of the commission, we ran through a number of reforms and we selected those for that first meeting, really thinking about the most significant and impactful ones that we thought it was important that the entire commission go through. What we're going to do today in the effectiveness and fairness subcommittees is go through the remainder of the inventory as we've broken it up into two categories, fairness and effectiveness. So the two subcommittees today are going to be reviewing different sets of initiatives that together comprise the entire inventory that staff has put together. And then we're going to share with you the results of the brainstorming that Sean referred to that was done at the conclusion of the first meeting. Those items fall under the purview of this particular subcommittee, so that you can see the ideas that you came up with at that meeting, and really hope that by the end of today, with the entire inventory of initiatives in mind that you've gone through, as well as the ideas you came up with at meeting one, that you'll be able to begin to identify 3 to 5 topics that you want to dig into. And that will be important in framing the work of this subcommittee for the next several meetings. So just reminding you kind of why we're taking you through what might seem to be a quite extensive list of activities that the Office of the Chief Trial Counsel has undertaken, because that sits squarely with the charter. And then to emphasize that the goal for the day is to come up with 3 to 5 focus areas to guide our next several meetings together. Does anyone have any questions about that? Comments? Does it make sense to everyone what we're doing? Okay. I see heads nodding, Sean, so I think we can
All right.
kick it off. Okay, great. Thank you. Thanks, Lisa.
Very good. All right, so we've actually already covered item A on our agenda. Thank you, Leah. Review of our charter. Let's move on to B, review remaining items from inventory of initiatives and policies related to effectiveness.
Okay, everyone, we have 3 speakers today to take us through the last set of policies and procedures related to the inventory for effectiveness. We'll just go ahead and start with, we have Hatem Khalek, who's the manager of IT, Melanie Lawrence, and then I will finish this off. So Hatem, are you ready to get going?
Yes, good morning, everyone.
Okay, terrific. All right, let's start with, okay, sorry, just before you get started, let's just review. So the topics we're reviewing has to do with the last subtopic for case processing, and that's a discussion of our new case management system. Then we'll discuss policies and procedures that are a little bit more focused. And then I'll finish off with a discussion of discipline system metrics. Okay, so go ahead, Hatem.
Good morning, everyone. Thank you for having me today. What I want to walk you through is the implementation of the new CMS, the actual platform that we're using, and what has been working and what are some of the shortfalls that we've been dealing with. And Steve is very familiar with them. So if we go to the next slide, please. So in 2016, we've implemented a court and justice solution from Tyler Technologies. The platform is called Odyssey. It's a widely used court management system across California and the rest of the country. It's essentially a COTS package, and it's a commercial off-the-shelf. And all that means is that it's a proprietary solution that is written and developed by Tyler Technologies. We don't really have a lot of ability to customize the solution. We can merely request some configurations and customizations, but Tyler will essentially have to do them. It is an integrated platform that allowed us to integrate all 3 components of the discipline system: state bar court, probation, and Office of Chief Trial Counsel. It also has a lot of built-in best practices, and it has an integrated document management function with scanning capabilities, so we can scan files directly into cases to help create the digital case file and eliminate paper. Next, please, Lisa. Why did we change it? Our legacy system was an old custom-written solution written in the late 80s. It was written by IBM. They call it the Report Program Generator, or RPG, which is really costly at the moment, and it's almost impossible to find resources that actually know how to write that code. We're still dealing with some of that in IT on one of our last remaining AS400 solutions for the Consumer Resources Office. The issue with that solution was it did not allow us to add modern functions, no web integration, and it didn't have a lot of flexibility in terms of configuration. It was very stable for a very long time, as all mainframes are, but there were some key functions and key new configurations we needed to do that it did not allow us to do. And it also did not have any document management capability in it as well. Next, please. When we set out to implement Odyssey, there were some specific goals that we really needed to achieve. One is improve the bar's ability to provide access to information a little easier. The new platform included a portal that the public has access to see all cases that are currently within State Bar Court and all the documents that associated with those and the dockets as well. We wanted to improve the data sharing amongst the stakeholders across the bar. And right now within the 3 departments, there's limited data sharing, but that's primarily because of procedural decisions that have been made along the way. There's been some automation of business processes that help reduce the case processing timeframes, and enforcing data integrity and the quality of data. And by that, instead of having a whole bunch of data elements that are text-based, we've kind of codified a lot of the values so that data integrity is preserved. And just about everybody using the system will have to select from a predefined list of codes and statuses and events and the likes. And also on the with that, we've added the ability for the public to submit complaints online. And then last year we integrated that portal with Odyssey so that the flow of case now start for the complaints will eliminate the need for scanning of complaints received or uploading it directly and creating the cases. Next, please, Lisa. Some of the benefits that have been realized with Odyssey is we've integrated the CMS for all the components. There is the ability to submit data and share between the 3 components directly in the system. That has been limited to by procedures that have been put in place. We're capturing a significantly larger amount of data with enforced rules, I guess, for data integrity. The integrated document management solution and scanning is allowing, for OCPC at least, eliminating the physical file. And I'm not sure if that's 100% yet, Steve, or not, but I know that for the majority of the cases, the documents are all being captured and scanned in the case within Odyssey. And then, as I mentioned, we've integrated with the online complaint submission portal, and that integration automated the case creation and having all the documents that have been submitted as part of the complaint directly uploaded into the system, eliminating the need for data entry to do that work manually. So that's been some of the efficiencies that have been gained. Next, please. With every implementation, while there's some benefits, we all have to also deal with the limitations of the solution, and there's certainly some with this platform as well. One of the things we've noticed with the platform is that the form generation capability, and that means the ability to automatically generate letters and documents with data from the system, is very, very limited. What we were doing before was a lot more efficient. That's certainly because we were doing it directly in Word, and we were kind of customizing these macros however we wanted. But we ran into some serious limitations with the form generation engine that is within Odyssey. We're also experiencing whenever we need to add new functionality in the platform that is not part of either a new release or a later version, the cycle for us to receive new functionality from Tyler is quite long. It's about, at minimum, it's 12 months for us to receive from the time we sign a work order, if you will, to the time we get the function. We're looking at roughly about 12 months. We've also noticed that the reporting engine in Odyssey, while it works well for canned reports that are kind of static, you just want quick statuses and quick numbers here and there, there isn't a true modern dashboard that allows you to do any type of analytics or metrics. And over the last couple of years, we've been doing a lot of these analytics externally to Odyssey, creating some pivot tables and Excel spreadsheets. But we are moving forward. We started that effort in the fall. We are implementing within IT Microsoft BI reporting tool, and we're going to leverage that to create a whole ton of we're going to migrate all of the Odyssey reports into Microsoft BI, which will allow the ability to do a lot of analytics, metrics, and provide some very dynamic dashboards. And then lastly is we've been noticing recently a slower than usual response from the vendor on issue resolution. We've submitted issues and it's taken them a bit longer to resolve. Any questions?
Eloise Rosenblatt, could you just explain, Tim, what OCTC and SBC means? I don't.
Oh, sorry. OCTC is the Office of Chief Trial Counsel.
Okay.
SBC is State Bar Court.
Okay. Thank you.
Sure.
Okay, I had a question too, Gary Farwell. May have answered it through the presentation. It was what type of data is to be shared, but I guess you were speaking of shared between those three entities, the OCT, the SCTC, and that type of thing, not sharing with the public and the state bar.
Correct. The public gets to see the data that is within the court. Anything that is any cases that are public are visible through the Odyssey portal that's accessible to the public only. Internally to the bar, the data is shared on a limited basis between the three departments as deemed necessary by the court, OCTC, and probation. But other departments do not have access to any of that data.
Okay, and then it seems really problematic if you're getting a slow response for problems and issues. It's like it could crash and it might be down for 2 weeks because of the severity of the problem, if the problems you're having already are being responded to slowly.
The solution right now is managed internally within IT. The slow response is on things that we've submitted that are not working properly. They're usually not severe issues that have been reported. For severe, in the event that the application crashes or we're not able to restore it, we have some escalation mechanisms in place that will escalate those types of issues and get responses from the vendor fairly quickly. But we don't want to resort to escalating every single issue we report. That's not a good, then we lose that ability when severe problems occur. But we are in discussions with Tyler leadership on how to fix these issues and how to improve the response that we've been getting from them.
Tim, I have a question as well, Linda Schneider. You mentioned that staff is using a reporting tool, I believe, from Microsoft to do your own analytics. And I think you said something like BI. What is the name of that tool?
It's called Microsoft Business Intelligence. That's what BI stands for. And we just started that initiative late fall or early this year, where we have licenses and we're going to be creating a whole bunch of Odyssey reports in that tool. And also we're going to provide training to staff to be able to kind of generate their own queries and slice and dice the data the way they want. So it's a much more dynamic reporting tool, if you will, and it will allow them to get the data that we wouldn't otherwise be able to get out of Odyssey without exporting a report into Excel and manipulating the Excel like we have been doing.
So I assume you don't yet have all of the analytical tools that you want to have, all the reports developed. You're still in the process of that?
No, we have the tool and we have some of the reports already developed, but we have a vendor that is helping us develop all these reports for all the three departments. So the effort is underway.
Okay, thank you.
Hatem, would it would it make sense to mention, we have a couple of, probably 2 full-time equivalent staff in our Office of Research who are devoted to extracting data from the system and reorganizing it and setting up. A lot of these spreadsheets that Hatem referred to actually come from a process of data extraction.
Am I the only one who
transformation.
can't hear?
Right.
So I think that's an important part of the reporting that is used for Office of Chief Trial Counsel for their internal management reports.
Right.
Gary, are you having trouble? I'm hearing fine. You're having trouble hearing, Gary?
It goes out and in. It said my internet is unstable, so I guess it's on my end.
Oh, okay. Sometimes if you turn your video off, if you're having internet problems, it might help with the audio. And there's also a call-in number you can use on your phone. So you could leave the video on and call in as well.
Tim, this is Karen Bell. I wanted to ask a quick question. I was at Orange County Superior Court when we implemented Odyssey.
Mhm.
And I know that at that time, this was a few years ago, there was a Tyler working group amongst some of the courts that were implementing Odyssey. Are you part of that group? Is that group ongoing?
We are not part of that group, and the reason is, we can certainly participate in it. But one of the things that we've noticed early on in our implementation of Odyssey is that the implementation in the majority of the courts that Tyler has implemented their solution is quite different from the implementation that we have at the State Bar because of the nature of the work that we do. Particularly within OCTC, for OCTC, we've had to, when we had to configure about 70% of the functionality to make it work for OCTC. So a lot of the things that we do, our processes are quite different from what the regular courts do. So it's been, we've been kind of in that boat, but there's certainly an opportunity for us to join these user groups, I guess, to see what they're doing or what's coming out of there. I did also forgot to mention that we are working currently. We do have an RFP that is going to be hitting the market, the street in probably a month or so to bring in an electronic filing solution that will integrate with Odyssey. And once that's in place, then we will be on our way to have a fully digital case file all around from the court, OCTC, and probation.
Thank you.
Ruben.
Thanks, Sean. Hatem, I was wondering about the delays from the vendors. Is any of that attributable to the pandemic challenges over the past 15 months, or does it precede that?
Some of it is. I think over the last year, specifically with the pandemic, we've noticed that it's a bit slower than normal. But in general, it's been a slower response, and we've been addressing that with Tyler leadership for a while now. But definitely throughout the pandemic, we've noticed an impact on that as well.
Thanks.
Eloise, did you have your hand up?
Yes, I had a question, Hatem, and this will probably come up again. I'm very interested in the how orientation of staff to analyze data is going to happen. This seems to me very critical because it's not just data management, which is immense, and I'm very impressed by all of the care that's being taken. I'm not a data person. I sort of cling to the underbelly. But what is the plan? And maybe this will come up in other presentations, but how is that orientation and calibration of staff to analyze data happening?
Well, from an IT perspective, our involvement right now is to take all of the reports that staff is currently using that are in Odyssey, and then the handful of new report requirements we've received, and then rather than building those reports in Odyssey, we're going to move to a more dynamic model, and we're going to train the people on how to use them. But the analysis itself is really going to come from the business leadership, the OCTC leadership and the State Bar Court and Probation on how they want to look at that data. And as Doug mentioned, Oriya has been key in providing data for analytics since the implementation of Odyssey, and I've stepped in to do extracts and be able to provide various management reports to OCTC in particular for their analysis. And certainly as it comes to the discipline system metrics as well that are being reported.
And I would just add that I think you've hit on something with how is staff being trained, but even going a step back further, it is the question of what is the data that's being collected and why. And so have we hit on the right metrics? We're going to be going over those a little bit later today, but I think that's a, great question for this group. Have we, identified the right things that we should be measuring? Understanding that much of what we measure is statutorily required, but not all.
Thank you.
Tim, I have a question. Sorry, I can't figure out how to raise my hand on here. But Alexia Mayorga, I'm the case management system that you guys are going to get in a month. Is that going to relieve the issues with sending out the letters and sending out information that you referenced you were having with Odyssey, because you'll have a different system that can handle that? Or is that not connected at all?
Well, it's somewhat connected, but the electronic filing solution is going to have an e-service component to it. So anytime there's court cases that are filed within the court, all the service for those cases will be done electronically. The issue of creating the forms within Odyssey, that is still an issue for us. And we're still trying to figure out whether an external solution that allows us a lot more flexibility and capability is something that should be considered and should be adopted. So it's not really going to resolve that issue completely. It will help in the, I guess, in the service of these documents.
Yeah, the e-filing solution will help in the transmittal of the documents to where OCTC would like to send them, but it does not help in the document generation. And that's really the key aspect and the key problematic part for OCTC at this point. We have, by adopting a modern case management system that takes more data than the AS400 mainframe system that Hatem mentioned before, we have reconfigured and retooled the office to put that data into the system with the assumption that we can then get better reports out. And you've heard some of the difficulty we've had in getting those reports and those analytics out. The other benefit of adding that data in is that when you're creating documents, whether it is a letter to a complaining witness or to a respondent or a filing with the state bar court, it can pull data out of the system and insert that data into the letter itself. So we're not having, in theory, to retype the respondent's name, the case number, the allegations, and things like that. Well, the reality is that, as Hatem said, the Odyssey system that we have, the form generation, which is really document generation, it is not capable of doing that. And so we are not only entering the data into the system, we are doing duplicative data entry every time we generate a document, because we have to enter it into that document by hand using a word macro that then asks, please enter the respondent name. We type the respondent name in and move on to the next prompt, and it will then complete that document, or for the most part will complete the document, but it deprives us of the benefit of having a modern case management system.
Linda.
Yes, thank you. I just wanted to follow up on that point by offering a solution that we had in our office. I was with the Attorney General's office until I retired. And we used a pro-law case management system, not Odyssey, but we had the same issue with document generation of, documents that are more or less repetitive. And what we did was use a product called Hot Docs to integrate with ProLaw to be able to generate the documents from the ProLaw system. And that was our solution, and it worked pretty well. So I just wanted to offer that.
Yeah, thanks, Linda. We've actually considered Hot Docs as an alternative as well. There's a couple of other platforms. And we did initiate a pilot last year before the pandemic, but that got stalled. So I think part of the discussions that IT is going to have with OCTC is, whether we can pilot a tool like Hot Docs, which is a pretty powerful document generation tool, and see what integration capabilities we would have with Odyssey, and see if that would be a longer term solution for us until the Odyssey document generation engine gets better. Thank you.
Okay. Any other questions? Comments? No. All right. Hatem, thank you very much.
My pleasure.
So let's move on to a presentation from our interim Chief Trial Counsel, Melanie Lawrence, about policies and procedures that improve efficiency.
Good morning, everyone. I have touched on a few of these in the introductory session, but I'm going to talk a little bit more in depth about them. And what I'm going to talk about today really are some of the major initiatives in the office in the last handful of years. They're not exclusive. There are a number of different ways that we have tried to improve efficiencies over the years. But these are some of the major ones, including structural changes to the way that the office works. And I'm also going to hit on some of the changes that impact the life cycle of a case. So can you go ahead and move on to the next one? So back in 2012 or so, our office moved to vertical prosecution. I mentioned this in my introductory remarks in our first session, but just to remind you, and it was quite significant change to the way that we did our work. Prior to 2012, we worked in a horizontal structure, and that essentially meant that there were staff assigned to work cases at various stages, but not to stay throughout the life cycle of a case. So, for example, there would be attorneys working with investigators to investigate cases. But if those cases were then going to move forward for prosecution, those cases would then move to another attorney to actually file the case, and then to yet another attorney to actually prosecute the case. It caused really some challenges with quality control. And part of the issue was that, part of the issue is that not everyone agrees about the theory of a case. And so what someone may have moved forward from an investigation stage to prosecution on a particular theory, the person actually getting the case may have a different viewpoint, and then may have to amend charging documents or perhaps settle a case. Also, it was inefficient in that when you have new people learning a case at various stages, it takes time, especially if it's a particularly complex case, to come up to speed at each stage that the case has moved along. And so the theory of vertical prosecution is that you have one attorney who stays with the case throughout the investigation, the pre-filing, and the post-filing stages. And so therefore, that attorney is not required to relearn the case at every stage. There's consistency in the theory of the case as it moves forward. The challenge to doing that, though, is you have attorneys then who are managing cases at essentially 3 different stages. So they have a caseload of investigation cases, they have a caseload of pre-filing cases, and they have a caseload of post-filing cases. And for some, that can be really challenging to just manage that at every level and make sure that cases are moving at each stage with efficiency. One of the other major structural changes was the second look process moved from our office to the Office of General Counsel. So what that is when we close a case at any stage prior to prosecution, and there's a complaining witness. The complaining witness gets a letter that essentially says if you disagree with the decision, you can request a second look. For many, many years, the Office of Chief Trial Counsel had a small unit of pretty tenured attorneys who served the second look function. And so it would go to OCTC attorneys to actually perform that second look. And probably about 6 years ago or so, that process was moved out to the Office of General Counsel. So there's a small unit of attorneys in the Office of General Counsel who serve that second look function. It's called the Complaint Review Unit. It gives some separation to the perspective and the decision making from our office to the Office of General Counsel. And beyond that, then a complaining witness, if they disagree with the Office of General Counsel, can move on to a petition in the Supreme Court. Another positive impact of this change in our office was that we could then take those tenured attorneys who had otherwise been dedicated to the second look function and assign them throughout the office to other assignments where we actually needed those resources. So it was useful in that respect. Also, the movement of the worker team to enforcement. So the worker team for many, many, many years lived in our intake unit. And it was comprised of attorneys and a position that at that time was called the complaint analyst. It's something less than an investigator. And cases that were coming through intake that were deemed to just require a few steps in order to make a decision on resolving a case would be kept in the intake unit and assigned to this worker team. So oftentimes it might mean that it required outreach to the respondent attorney for a response, for example, or more information, excuse me, from the complaining witness. So the staff would reach out and do that. And so these were generally low-level cases, and upon receiving whatever information was deemed important to make a decision on the case, those cases would oftentimes resolve at the intake level and never move forward to investigations. Sometimes they would resolve by a closure. Sometimes it would just might be something less than discipline, for example, a warning letter. And so it really allowed them to be very nimble. It didn't require all of the process that is required of cases as they move forward to investigations. But this function was moved to the enforcement unit, I want to say maybe 5 or so years ago. And it had the effect of essentially moving a volume of cases then into the enforcement unit with all of the process that was then required of investigations. And so it really slowed these cases down. So for example, in most instances in investigations, the staff are required to draft an investigation plan, also to reach out by letter to the respondent attorney. These are things that were not necessarily required when cases were worked by the worker team. And so these lower level cases, as they moved forward, then ended up slowing down considerably as they moved forward to enforcement. Also, in about 2016, 2017, as part of workforce planning that I mentioned in the first session that our office was required to undergo. Whereas prior to this movement, many of our teams in enforcement were specific teams. So for example, they would work cases that were implicating fraud or misappropriation or the unauthorized practice of law. To the extent that those cases could be identified in the intake unit and were moving forward to investigations, then those kind of cases would go to specialized teams. As part of the workforce planning process, the recommendation was to have more generalist teams and not to have staff who were specialized in those particular areas. I think the theory behind it was to provide more opportunities for more staff. And also, it really had the impact of teams that were overburdened with some cases rather than others. So for example, teams that were specialized in performance-related issues, because many of our cases implicate performance-related issues, those teams would have to manage a much higher volume of cases than, for example, a team that was handling a fraud kind of case. So we moved to more teams. We added supervisors, and they are generally speaking generalist teams, with some exceptions. And that includes the other two teams that you see here. So we have a training and calibration team, and that was added around 2016, 2017. And the idea in particular with the calibration team is that when we moved forward with workforce planning to create all of these teams and generalist teams that, and we pushed down approvals so that most work is approved at the supervisor level. So that is, for example, charges that are going to be filed, levels of discipline that are going to be sought. Those decisions are now made by supervisors, wherein prior to workforce planning, those decisions ultimately were made by managers, a very few managers versus several supervising attorneys. And so the idea with the calibration team is when you have that many people making decisions, you want to maintain consistency in decision making. We want to make sure to the extent possible that we're treating similar allegations similarly in terms of how we're charging them, and also in terms of the levels of discipline that we're seeking. So we have a calibration team that has a bigger picture view of the office, looks at, for example, notices of disciplinary charges, also stipulations that we enter into after the fact, decisions that are coming out, so that we can see where we might have challenges with consistency and try to bring us all together. And then the training team, which prior to this, it was sort of catch as catch can in terms of training, who's available and what do we need. And now this is a small team that integrates actually with the calibration team so that I can identify those training areas that we really need to concentrate on. They also are responsible for training our new staff pretty exclusively. And they put on throughout the year MCLEs and other training that's required to make sure that we're calibrating. And then also the non-attorney unauthorized practice of law team. And this is a team that came together in about 2016. And it concentrates exclusively on those folks who we actually really have quite limited jurisdiction over. They are not attorneys, but they are potentially engaging in the unauthorized practice of law. This team consists of 3 attorneys and I want to say 4 to 5 investigators and a paralegal. And so they can focus exclusively on these kinds of acts. The challenge in doing this, and while it's important and they have a fairly heavy caseload, when we moved people to this team, we did it because there was an obvious need. There really wasn't a place for people to go, for the most part, who were complaining about individuals who are engaging in the unauthorized practice of law. So we served that function. But we didn't get any additional resources for this kind of specialized team. So we had to move people who otherwise would be working our regular discipline cases into this specialized team. Can you move to the next slide, please? So also, aside from the structural changes, we have managed some other changes to try and help move our cases more quickly and more efficiently. And this is on our minds regularly because I think we touched on it in the introductory session. We are supposed to be moving to resolve our cases within 180 days. So that's 180 days between the time it walks in the door in intake to the time it resolves, whether it's by a closure or whether it's by a filing by stipulation or notice of disciplinary charges. And this has been a huge challenge for the office for many, many years. And we have looked at a variety of ways in which we can improve upon the efficiency of our actual process. So some of the things that we've done, you see here. So we focused on making some changes to our rules of procedure. The first one here is changing from mailing letters to respondents requesting a response, and instead posting it on the My State Bar profile page. So prior to this, and I think I mentioned earlier that in our investigation stage, we are required to give notice to the respondent attorney that they're under investigation, what the allegations are, and to request a response. And attorneys are required to cooperate during an investigation. And so we were mailing, back in the days when people mailed letters, that's what we were doing. We were mailing these letters to their membership records address and, waiting for a response. Sometimes we wouldn't get a response. We would mail a second letter, and just the delay in the actual, US Postal Service, even waiting for them to mail a response back takes time. So now with the change, we can actually, instead of depending on the US Postal Service, we can actually, what we do is we post the letter to the attorney's state bar profile page, and we send them an email telling them that a letter has been posted to their profile page so that they can access it and read it and respond. And then the other change also related to this inquiry letter is a change from an automatic 2-week extension for a response to an extension if they demonstrate good cause. So the way that it worked prior to this is when they got the first letter, in most, if not all cases, a respondent attorney or their counsel would simply say that they wanted an extension, and so they got an extension. So a 2-week response now became a 1-month response, if we were lucky. And now the rule requires that there must be a demonstration of good cause for an extension of time to respond. So that helps in cutting down that time of it. Can you move to the next slide, please? So also looking at our post-filing stage and beyond. So prior to about 2013, 2014, before we would move a case to filing, we would engage in something called a 20-day meeting. And this was not required by rule. It was an office policy. And what this meant is that we would reach out to the respondent attorney or their counsel prior to even engaging in what we are required to do, and that is offering an early neutral evaluation conference, which is a post-filing settlement conference. So we would reach out and basically say, we're looking at filing charges. We're interested in meeting with you and having an informal conference. And oftentimes the respondent and or the respondent's attorney or both would come into the office and basically sit down and have a meeting with the attorney who was handling the case, in exchange of information, a discussion about evidence and potential for settlement. And if we were not able to settle the case then, we would then issue a letter basically saying we were going to move forward for filing and that they were allowed to have an early neutral evaluation conference if they so chose. And then we go through that process. Now, that process, that being the early neutral evaluation conference, is something that we continue to do. It's required by rule. But the policy related to having a 20-day meeting, that earlier informal conference, was eliminated. So that now we can simply move on to the early neutral evaluation conference. So there are still opportunities to settle these cases pre-filing. And so then some other amendments, and these are rather new amendments. They were sort of inspired by the pandemic, but really forward-looking in terms of sort of how we want to be doing business in the future, how many other courts do business now, and in contemplation of the electronic filing and service process that Hatem mentioned. So prior to some of these amendments, these rule amendments, our office would, in all instances, and in particular cases that looked like they were going to go forward to filing and potential trial, we would be seeking certified court records. And so we would have to subpoena records from courts. We would have to wait 30 days, maybe longer, to actually get court records. And now the rule allows for, at the trial stage, the introduction of non-certified court records. And it requires a few steps to get there. But what it allows us to do is to, in any instance where we have a court where we can actually access documents online, we can simply print those out. Or we could seek records directly from the court, but not have to have them certified, which has a tendency to take more time. And so that we can actually introduce those records as exhibits now at trial without having to have the certification. So that has allowed us to move cases with more efficiency and cut down on the cost just of certifying records. And it's been particularly impactful when it comes to federal records. Those can be quite spendy to actually get those records certified. And then also, this one in particular is the one that happened this last year. So we are now able to serve documents electronically, use electronic signatures, which has been particularly important with Odyssey and also with the pandemic, so that people don't have to do wet signatures, they can do electronic signatures, and also exchange and lodge trial exhibits electronically. This is also hugely impactful for our work because prior to this, we were required to produce trial exhibits by paper. And also multiple copies. So one for the respondent, one for the respondent's attorney, one for the witness, one for the judge. And then of course our staff would have one themselves. And there are some cases where trial exhibits are particularly voluminous and require a significant amount of work on the part of our support staff to actually print them. We're killing trees, we're putting them in binders and shipping them out. So they would take a considerable amount of staff resources to do this. Now we can simply actually exchange documents electronically, which is obviously much easier to do. I think a lot of more people are doing that in their practice these days. And we can also lodge those exhibits with the court electronically. There are some instances where we still do paper. For example, if the respondent has a need for paper exhibits, is not able to actually produce or access the exhibits electronically, and on occasion the court will want paper exhibits. There is an original exhibit that goes to the court that is paper, because it eventually is transmitted to the Supreme Court, and those are transmitted by paper exhibits. So, okay. Yes, okay. Any questions? I can't see everyone's.
Yeah, I saw Judge Wayne. I saw your hand up, and then I saw Linda Schneider.
Gary Falwell too, please.
Okay, thank you, Gary.
I did put my hand up, but then Melanie did clarify in terms of the original paper exhibits. So this might be something we need to kind of consider moving forward in terms of the Supreme Court, and Greg's here. But the Supreme Court still requires the paper set. And I think things may change, depending on how we proceed, if we're going to stay in this hybrid mode and do maybe some remote trials and some in-person trials, but things will be changing depending on Emergency Rule 3 and how the State Bar Court proceeds with regards to the paper exhibits.
Hey, Linda.
My question is relating to the 180-day goal to either close a case or file it. And it is whether the early neutral evaluation conference is part of the pre-filing within the 180 days, or if it's part of post-filing after the 180-day goal.
Sure. So it is part of the 180 days. And that's something that's quite challenging for our office because a lot of the timing of that is not within our control. There are some rules related to, how long the respondent has to actually request it. And then of course, it's also dealing with the court's calendar. So, with some frequency, we could be months into that process, and it's cutting into that 180 days.
I had a feeling that was the answer, and that's where an area that I would think might need some refinement or revaluation. Because
yes,
it's really not fair
yes.
to hold that against the state bar when it requires coordination of everybody's calendar.
Right.
And 180 days is a very short time. So I wondered about that. Thank you.
Yes, sure.
Okay, Ellen, and then Gary, you're next.
Okay.
Thank you. I actually had a question for Melanie and then a comment as well. I was just wanting to go back to your collaboration team. I'm not quite clear if it's a single team that does training and collaboration or two different teams, but I'm focusing on the collaboration part. You had said that previously decisions were made by supervisors and not managers, but then there's also a collaboration process to promote consistency. And I'm just wondering who's performing that collaboration process, which I hear must be some sort of oversight to harmonize what each of the supervisors' vertical units are doing.
Right. Okay. Well, maybe I misspoke. I don't know. So let me clarify. So prior to the training and calibration team, the way that it worked is, well, first of all, we didn't really have supervisors for the most part. There was a time where there was a pilot program for supervisors, but nothing really set in stone where we had all these supervisors that we have. So charging documents that staff were drafting, our charging memos and our notices of disciplinary charges, levels of discipline, et cetera, were going to the unit manager. And that person was the one then that was signing off on, the charges and level of discipline, et cetera. And, there are very few of those. So when we went into, after workforce planning, when we had all these teams, we added all these supervisors. And instead of requiring management approval of the charging documents, the levels of discipline, et cetera, that authority now rests with the supervising attorney of each of these teams. So in terms of calibration, first of all, the training and calibration team are largely made up of the same people, and there are just a handful of them. Now, part of the challenge with calibration is it comes after the fact. So they're not reviewing documents prior, for the most part, prior to filing. They're looking at, how have we done in terms of stipulations, for example. So they're looking at office-wide, all of the stipulations that have been entered into. They're looking at hearing department decisions, office-wide, were we consistent in the levels of discipline we saw? And that particularly comes out when you're looking at stipulations. When you're looking at it from that perspective, you could see, if you're looking at 20 stipulations, you could see, for example, the same kinds of misconduct and similar aggravating and mitigating factors. And yet, depending on the team, they're different in terms of where they are with the level of discipline. And so sort of asking those questions and trying to highlight that for people so that we can, in fact, be more consistent going forward. And I'm sorry, did I answer your question? Did you ask me another question?
No, I think you answered it.
Okay.
And I just wanted to comment that I think that we should spend some time looking at that because there still is a great deal of inconsistency. And I think that may be part of the overlap with the fairness subcommittee. So I do think that this bears a close look. And then I just wanted to very briefly say that I agree with the comments that Linda made before mine. The 180 days is not workable in most instances. So I think that should be revisited. Thank you.
Sure. Gary, and then Eloise after Gary.
Okay, thank you. Let's see, I may have more comment than question, but when I received a letter from the state bar via email, the first time I received the same letter more than once, but in the time period, I think I ignored the first one because I thought it had something to do with my dues because it came right around the time dues were due, but I hadn't paid mine yet. The deadline may or may not have passed, but it was very close. So I kind of didn't pay attention to it. So I think something may need to be changed so it's clear that that's not what the letter was about. You know, because I saw that, you know, they needed to talk to me about, but it didn't dawn on me that it was something other than my dues until after I paid my dues, and then I got the letter again. And so I paid more attention, and it was about some complaint. Okay, that's one thing. The other thing is that, okay, yes, agreed, you can settle your case via email, but I tried to do that by responding to the investigator and just sending her information in a responsive email so she could call people and check with people that would resolve the case. And that wasn't good enough. I think what I had to do, as I recall, this happened last year, she still, even with that email and with all the information she needed, she sent me a questionnaire that I had to respond to. That was just a waste of time, really. All she had to do was look at my prior email and make a couple phone calls. So anyway, there needs to be some better and more flexible at the early stages ability to resolve the cases instead of just going by. It's great that at first her response seemed like I couldn't do it via email, that I had to do something else. But she said, no, you can email me, but I had to email the questionnaire or a letter or something. I couldn't just respond to the email like you usually do with the answer. You know what I mean? I had to go through something with an attachment and do it that way rather than telling her what she needed to know. So anyway, those are my two comments.
To your first one about the email that we post, I mean, we have been mindful about the information that we include in our email. And the reason for that is, you know, there are attorneys who other people have access to their email account, including their support staff, et cetera. So because investigations are confidential, we don't want to reveal in our email that it's pertaining to a confidential investigation. So it is rather general email that's sent that essentially says something to the effect of an important document has been posted to your membership profile page. So that's the reason why that happens.
Okay, thank you. That makes sense. I understand that.
See some other hands. I don't know who was first.
I think Eloise was next.
Thank you, Sean. I wanted to follow up, Melanie, on Ellen Pansky's mention about calibration. I remember the first presentation, you have just such an enormous staff. I think it was over 260 people, as I recall. So I'm wondering, I wanted to focus on the supervising attorneys that I understand have succeeded the unit managers. Did I hear you correctly?
In their function, yes.
Okay, so the supervising, I guess I was just wondering about the qualifications. When you say you have senior attorneys, I assume that everybody comes in, you know, is hired with a different set of qualifications, and there are budget restrictions. So I'm just wondering, what are the bottom line? What is your threshold set of qualifications for supervising attorneys? Are they required to have experience, you know, in actual practice, or are they, you know, having represented clients themselves, or are the issues that you've defined separate from having had actual experience trying cases, representing clients, dealing with opposing counsel, you know, performance issues? Do they have to have performance experience?
Right. Well, unfortunately, I don't have the job description in front of me, so I'm going to speak in generalities. They do have to have years in practice, but it's not focused necessarily on the type of practice, although I will say, practically speaking, and because these were added in 2017, the majority of the folks who at least initially served in the positions were people who had been in our office for years. They were the most obvious people to do that. They're more experienced in our area of law. Although, one of the challenges is just because you're, a good attorney or well-versed in our area of law does not necessarily make you, a great supervisor. So it's finding that balance. There are people that we have promoted into those positions in more recent years that have less experience in our office, but they are certainly tenured attorneys. They come from a variety of different backgrounds.
Could it just follow up? When you say tenured attorneys, you've used that phrase several times. What does your office mean by tenured attorneys?
Well, I would say generally anybody over 10 or more years of practice. That's my definition when I'm using it.
Okay. And practice out there or practice in your office?
Any combination.
Okay.
Any combination. I mean, if we were limiting it to people, who had practiced for 10 or more years in our office, we would have a very small number of people to draw from, and not necessarily folks who, would be ideal supervisors, for example.
Because to me, this is, because these judgments are being made, even though you have a very sophisticated data management system, there's always the, just the intuition or the judgment or the preference or, what a recent book is called noise. All of those factors, what the experience I've had, the experience I haven't had, what I think I ought to do, where I live, what this issue triggers in me. So I think this is what Ellen Pensky brought up. And it's important to me, not just who's calibrating or the calibration process, but, how is judgment and, those intuitions and those very personal, sometimes idiosyncratic decisions being made, because I think this ends up, affecting the numbers about who gets disproportionately brought to trial or named as, having problems.
Mm-hmm.
So anyway, there's just more a comment on your very tough job, Melanie, very tough.
Okay. All right, Karen.
Mute myself. So Melanie, I don't know if you're the right person to answer this or not, but I guess I'm struggling with the sort of opposition between the goal of preventing future misconduct with the fact that the investigations are confidential and so much of what happens in the office is confidential. And I'm just wondering how these lessons, these lessons learned get translated to the bigger legal community so that we can all learn, right, from the mistakes that are made. So I get that, I understand, of course, the focus on privacy and confidentiality. But I'm just wondering, is there an effort then where, because you almost, know so much about what goes wrong, right? I mean, you see what goes wrong every day, whereas those of us that are out in just the world practicing, we really don't see that. We don't really focus on that. And so many, I wonder if these lessons get lost for the bigger legal community and sort of on the prevention side. That's really important, but maybe there's efforts out there that I don't know of. So could you speak to that?
Sure, absolutely. Well, I definitely think it is an area where we can do better, and it should be more robust in terms of our proactive efforts. But what I will tell you that we do, and we've done for a number of years, and in particular of late, we've added to it. First of all, I mentioned CTA and ethics school, I think in the first session. And that's something that now, because of the pandemic, and I imagine that we will continue to do, we're offering it remotely, which expands people's ability because they don't have to actually come to the San Francisco office or LA office. And interestingly enough, and I just looked at the numbers last week, the numbers of people participating in those efforts have grown over the last year. We've seen many more participants. But the other things that we do, first of all, I mean, we're often asked to engage in speaking engagements for different bar associations, different particular offices, prosecutors' offices, PD's offices, et cetera. And we do that. It's generally a standard presentation overview of the discipline system, but we always talk about common issues, common complaints, common problems that people have. And most recently, in the last few months in particular, we've also been participating with some of our other state bar partners in law school presentations. So we're going in and we're talking, it's a little bit of a more brief overview, but we definitely talk about some of the issues that people are faced with, make some suggestions about resources that are out there, and plant the seed for future attorneys who might want to join our office. So we do that, but oftentimes it's when we're asked. So I do think that there are more opportunities for some proactive efforts.
I would just add that some of the other things that we are working on in that area include an online self-assessment that's coming up for the client trust accounting specifically, but we envision it more broadly in the future to include all areas of practice management. So somebody can come in and sort of go through this self-assessment and see what they're doing and how that matches up with best practices. And as part of that, it will include some discussion of here are some of the pitfalls and here are ways that you can avoid them, things like that. Another thing that we are working on is sort of a similar piece, but more specifically designed to target solo and small firm practitioners, to let them know what areas they are potentially vulnerable and how they can avoid ethics complaints and things like that. We have partnered with the solo and small firm section of the California Lawyers Association over the last couple of years to work with them. One of the things that we're doing is we're, after several years of development, finally getting to a place where we can start to send out a letter when somebody changes, for example, their practice sector or practice size from a large firm or a government practice to a solo or small firm practice. We can reach out to them with resources on how to avoid problems in their practice, congratulating them on their practice, so on and so forth. Another thing that we've talked about doing is once we can get we've been working hand in hand with Oriya to get a lot of data. We really manage not just the office by the data that's required by statute, but we also really run the office based on data and analytics. And so we've worked very closely with them to develop a number of reports. One of the things that has been sort of central to that and is a project that we hope will be launched this summer is a allegation classification project, so that when we have all of these different allegations that people can be charged with violating, and if we can classify them into sort of bigger buckets, if you will, we can then take some of that general lessons learned and go out and talk to the Solo and Small Firm Summit for the CLA and talk to them about ways that they specifically are most likely to get into trouble and ways that they can avoid that. And so that's sort of going back and providing more detail about the disparity between solo and small firm and large firm that we've sort of touched on before, but it's also appropriate to talk about here.
Thank you so much. That's really interesting. It's great to hear that all that stuff's going on. I didn't realize that. Thank you.
Okay, Cynthia.
Hi, good morning, Melanie.
Hi.
How often would you say closed cases get a second look by general counsel?
Well, we have the statistics on that. I actually think that might come up in the next metrics segment. I don't know what the percentage would be, but Lisa, are you going to talk about that in your metrics discussion?
Yes, I am.
Okay, so hopefully I think she'll be able to answer your question.
Okay, thank you.
Ellen.
just wanted to follow up on something Steve said. Way back when ethics school first came into being, trial counsel would publish statistics on recidivism rates for people who had attended ethics school. And I think that was even before there was a CTA school. And my recollection is that the recidivism rate was very low, I think somewhere around 3%. And I'm wondering, are you keeping statistics on that now? And if not, would it be possible to do so?
I feel like Lisa might actually be touching on that. I'm quite sure I saw recidivism as one of the topics on one of the agendas today.
Yeah.
Lisa, is that, yeah, okay. And I think it might include that specific information.
Yeah, the board and some of its commissions or task forces have heard extensive statistics about recidivism. So it's an important question. So we have that data.
Do we have it breaking out recidivism for those who participated in CTA school versus those who didn't?
No, we do not.
Good point. Okay. Unless there's anyone else who wants to speak, we've been going for about 90 minutes. So why don't we take a break and come back at 11:35. So 11:35 sharp, we'll be back starting up. Thank you all. welcome back. All right. Next up is Lisa, who's going to give us the long-awaited metrics presentation. Take it away.
Terrific. Hi, everyone. We have a set of metrics that we use to measure our discipline system, but all offices within this discipline system have a set of metrics, but so do offices in all functional areas of the bar. And that started in January 2019. So for example, finance has metrics, HR has metrics, my office has a metric, and a couple of metrics. And the purpose of these metrics, and when established in January of 2019, was to first and foremost to illustrate impact of the various different functional areas. Also give offices an opportunity to identify areas for improvement, but also celebrate successes. And so we, like I said, all functional areas of the bar have metrics for their offices. And we report, and some of these metrics they have to report them at the monthly level. Some of them are reported quarterly, some are semi-annually, and others are annual metrics. And my office is tasked with working with these offices to gather their data, report their results, and we package all of the results of these metrics and report them to the Board of Trustees 3 times a year. So what I'm going to do in this presentation is focus on the metrics for the offices that are under the discipline system. Okay, next slide. Okay, so the offices under the discipline system are the Office of Chief Trial Counsel, State Bar Court, Probation, Client Security Fund, and the Lawyer Assistance Program. Across these 5 offices, there's a total of 31 metrics. Of the 31 metrics, 19 have targets. And so what I mean by a target is that a metric will have a goal that it's supposed to meet. So whether it's process cases within X number of days, others are things like maintain the success that your office has been experiencing, maintain that success, things like that. The reason why only 19 out of the 31 have targets is because some metrics it's not really appropriate to have a target for a variety of reasons, but they're still metrics in the sense that we're reporting them, offices are required to report on them just for the purpose of reporting so that we can observe trends over time, for example. So I'm going to go through the reasons why we have this, or rather go a little bit more in deep into why. And so some of these metrics, for example, they're focusing on how efficient their operations are. Other metrics report cycle time, like how long it takes to do something. Other metrics focus on how much a resource is being used in an office or by customers. Other metrics actually measure customer responsiveness. So for example, most major offices are measured on the extent to which internal staff are satisfied with their internal customer service. Other metrics actually measure outcomes, which is like your office does this, tell us the percent, whatever. And finally, other metrics measure quality. And so when you look at across all the offices, these don't apply to everyone. So in most cases, for most offices, their metrics focuses probably around 2 to 3 of these. So what I'm going to give you now is a couple of examples of metrics that are for across these different types of focus. Just let me pause for a second. I am so sorry I got to you just too late this morning when I shared with you a list of all the metrics. But if you go to the OneDrive folder, there's a PDF there that shows all the metrics for the discipline system that we're tracking for 2021. I also included in there an example of the most recent report to the Board of Trustees, most recent metrics report. Okay, so here's an example of 2 metrics that measure cycle time. So the one on the left is for OCTC. And they have a goal that they're going to maintain an annual caseload clearance rate of at least 100%. And they're required to report this metric on a monthly basis. So the way we report this to the Board of Trustees is on the left is always the target. If the metric has a target, it's always on the left to see what the target is. And then on the right is the result. And so an annual caseload clearance rate, it's not so much of, it's measuring the number of cases that are coming in to the number of cases that are cleared. But rather than looking at it monthly, an annual caseload clearance rate takes into account the average monthly caseload clearance rate over the previous 12 months. So that way it's going to get rid of kind of like fluctuations that you could see. So for example, say 1 month, the caseload clearance rate was like 90%. And then the following month, it was 110, that could average out to 100. And so it takes into it. So when you see the value for December 2020, 109%, that takes into account the average of the previous 12 months prior to December 20th, including December 20th. So that's OCTC's metrics on cycle time. On the right, here's an example of a metric for the State Bar Court. There's a goal there that 90% of cases will be processed within their case type timeline. And the State Bar Court sees several types of different cases, and these different cases have different case timelines. And so again, on the left, their metric is, the goal is 90%, as you can see every month that we, in the most recent measures, they met it 100%. And then we also know if there was a month where no cases reached final outcome, we note that as well. And so that's there in December.
Lisa, can I just interrupt for a second?
Sure.
So these statistics are for a very short period of time. Can you, I think the statistics in 2020, thankfully, have been better, but this has not always been the case. I don't think for 2019 and 2018, OCTC was processing more cases than came in, but correct me if I'm wrong. I just want the commission to have the big picture. And of course, Melanie can comment too.
I guess I'm just sharing the results from the most recent metrics report. But yes, for a while, OCTC did not meet this metric, I believe, because of the transition to Odyssey. There was a bit of a delay there, and it took a while for those months to come out of the annual caseload clearance of the 12 months. But once we reached past that hump, they've been meeting it consistently.
Right. So the Odyssey implementation slowed them down, understandably. And there was also a surge, and I forget the exact period of time, but there was a kind of a temporary surge in complaints in the last few years that has now been processed and bogged the system down a little bit. But it does show you how, and the reason that's important is that it is very difficult for OCTC to keep on top of this volume. And when there is a temporary spike in cases, it can really slow them down quite a bit. So,
hey, Sean, this is Brandon, if I could. So one of the other factors was that we had opened up the online portal system. And so we saw a surge in cases from that system, but no corresponding decrease in the amount of written response or hard copy complaints that were also filed. So I think we're dealing with that dynamic, as well as the onboarding of new employees that were hired based upon the fee increase. So those were the three dynamics that I recall being significant during that time period that you referenced.
Good, thank you.
Yeah, that's correct. The influx of complaints began in July of 2018, continued over that 6 months. The online complaint portal went live in October, and then in February of 2019, that was continuing, and we went live with Odyssey. Our caseload clearance rate dropped. In February, March, I want to say something like 67% or something like that was our caseload clearance rate for that time frame, and it slowly increased from there. But we really didn't get over 100% until after that. February, March dropped out of the 12-month rolling average the following year.
Good, thank you. Okay, Lisa, carry on.
Great. Okay, so here's an example of a metric that's measuring outcomes. This is probation and its successful completion rate. So it's the percent of probation cases that were completed successfully. This is an example of a metric that has no target. And it's just, again, we're just preparing these reports for to observe trends over time, et cetera. And the thing about probation is that there's a very specific number of cases, the types of cases that are included in this metric, and we include that information here at the bottom.
And what's the definition of successful?
I believe it's actually, I'm sorry, I don't know. Can't think of it off the
It's
top of my head.
completing the terms and conditions of probation.
Okay, thank you.
All right. We also have metrics that measure quality. So here on the left is that a metric that pertains to the complaint review unit. And the baseline, the target for this metric was to maintain the current level. And so when the metrics were formulated in January 2019, we looked at what the baseline was in 2018, what the value was there in 2018. And we said, OCTC, 2% is great. Only 2% of cases that go to the complaint review unit are reopened for reasons other than new evidence. Maintain that. And so this is an example of a metric that we measure every 6 months biannually. And as you can see, here's all the data for 2020, and in both instances, they met that metric. Here on the right is another measure for OCTC's quality of work, and it has to do with the number of Walker reopens, and that has to do like if a complaining witness wants to take their case to the Supreme Court, they can. It's called a Walker petition that they file. And in 2018, that baseline was only that the Supreme Court only reopened the case or sent it back to OCTC one time. And so the idea is to maintain that. And in 2020, zero Walker reopens occurred in 2020. So this is an example of meeting that metric. And so both these are examples of metrics that are meant to measure the quality of OCTC's work.
And let me, Lisa, let me just supplement that. Just two things. First is just because commission members are learning a lot at once, I just want to remind you, these are the two opportunities that a complaining witness has if OCTC decides not to prosecute a case, to seek reconsideration of that decision. The first is the complaint review unit in the Office of General Counsel. And then if they don't both suggest to OCTC to reopen the file and OCTC agrees and does that, then they have an opportunity to file this petition with the Supreme Court of California. As you can see, the rate of Walker petitions in recent years being granted is very low. There was a time, I forget the year, Steve will probably remember, that that the Supreme Court granted, well, actually they weren't Walker petitions. No, there actually was a period in history where the court had granted a number of Walker petitions, and that resulted in some internal study at the bar. I'm thinking of the stipulations being returned, and that's different. The point being with the Walker petitions is that we know the court looks at them very carefully because occasionally they do grant them. And sometimes the grants indicate a high level of detailed review. So that's a very meaningful mechanism for complaining witnesses. This is the reason I mentioned that.
And Sean, I can just to add on to that from the court's perspective. We call them accusations, Walker petitions. Each accusation that comes in is assigned to a staff attorney. They review the case file. So in certain cases, if there's an issue, they will request the investigation file as well. And a individual memo is drafted for each accusation that comes in and is added to the weekly petition conference for the justices. So they are looked at in detail, even though there's a low number. The court is actively looking at each one of those Walker petitions to make sure that it was closed there was an adequate basis for closing that particular complaint. What you were also alluding to before about stipulations, the court each year will conduct its own internal audit of cases that come up to the court. So the cases that will always come up to the court because they require a court order are any case resulting in a suspension or disbarment. Of course, respondents can petition for review on something that results in lesser discipline, and OCTC can also seek court review in those cases as well. But those cases do have to come to the court, and what we will normally do is take a set of cases in which no petition has been filed past the jurisdictional deadline, and then we will take a look at a sampling of those cases. At times it's probably somewhere in the neighborhood of 75 to 50 cases, and we'll review them just to see are the standards for attorney sanctions being applied uniformly? Is it well supported? And we'll generate our own internal audit report to the justices that they review.
Good. Thank you, Greg. Okay, Lisa, back to you.
Okay, so those are examples of metrics that pertain to quality. And then finally, here's an example of a metric with regards to customer service. I mentioned that all or all offices have metrics related to internal customer service, but here's an example of an office having a metric related to customer service of external clients. And in this case, this is a lawyer assistance program. And so they survey all of their survey participants regularly to gauge their satisfaction. And this is a metric that, and the goal is 80% of survey participants will report that the LEP addressed their goals. And as you can see, they met that metric in the last 2 quarters measured. Okay, so I don't think I have any questions. I can pull it. Let me just stop sharing. I'm going to pull up the list of OCTC metrics just so we can see it together.
Okay, and while you do that, Lisa, I'm not sure we answered Cynthia's question. Cynthia, I think you had asked about the number of cases sent to CREW, the complaint review unit, each year. I believe that's what you wanted to know. So I just pulled up the annual discipline report. It looks like in 2020, there were 966. That was kind of a low. There had been 1,600 in 2019. So in the metrics report, we're identifying or sharing the percentage of those that actually get reopened by the complaint review unit, but that's the raw number. So somewhere between 1,000 and 1,600, it looks like over the last few years annually.
Okay. Thank you, Lisa.
Okay.
All right.
Well, I think
go ahead.
Lisa, I just wanted to share, like I put a document in the share drive. It looks like this. It's a PDF and it goes for every office in the discipline system. Here's an example. Let's just go to OCTC. Most of their metrics focus on cycle time and quality. And here's like our metric internal tracking. Here's the name of the metric and here's the timing of the reporting. So as you can see, the first, we measure P1 cases in backlog, resolve 100% of P2 cases within 120 days. We have lots of different metrics for OCTC. So anyway, I just wanted to give you a little, I'm so sorry again that I apologize for not getting that to you soon.
Good. Thank you, Lisa. All right, so let's move on to item C on our business agenda, which is decision on initial areas of subcommittee focus.
Okay, let me. Okay. So the first thing we were going to do is just do a little like refresher of everything that we talked about across our 2 meetings so far. And it looks like our effectiveness was broken down into like 3 big buckets of work. The first was case processing, and we addressed the first 3 subtopics at our first meeting. And today, sorry, the first 2, and then you heard the last 2 today on the case management system and policies and procedures. At our last meeting, I discussed recidivism and the data we collect to address to learn more about that. And then today we talked about the discipline system metrics. So it looks like we reviewed the entire inventory. And then so does anyone have any questions about this? Confirmed, everyone confirmed that we reviewed the entire inventory? Okay, great. Okay. And here is a summary of the topics raised at the end of the April 30th meeting that pertain to effectiveness. One suggestion was to discuss, and the purpose of, the reason I'm going through this is just a little refresher, so then we can now see if you have any additional ideas besides these. So the first is preventing and supporting mandated training for solo practitioners, aging attorneys with substance abuse problems. Another topic of interest was options available for diversion. The other one was greater flexibility in discipline standards. And then here is investigator use of public records to give context to complaints. So I guess that has to do with case processing, increased use of stipulations and settlements, recidivism metrics, confirming how we measure that given the system's nuances, and the role of malpractice insurance. And so now we can see if you have any additional ideas. It's all kick this back to you, Sean, on how you'd like to facilitate that discussion.
Sure. And then of course, we're going to go back and look at the roster of ideas and figure out which ones to focus on initially, so we can, but if anyone has any additional suggestions, one thing I will tell you that we're working on at the board level, and I don't think it's ripe for discussion at the commission level yet, is we are looking at our governance structure in terms of the Office of Chief Trial Counsel. So as you may remember from the presentation last time, the board has a committee called the Regulation and Discipline Committee that is effectively a committee of the whole of the Board of Trustees. And the Chief Trial Counsel reports to RAD. The board hires the Chief Trial Counsel, but the statutes tell us that the Chief Trial Counsel is to report to RAD. And one of the things we're looking at is having enhanced interaction with the Office of Chief Trial Counsel around policy. So there's kind of a division between judgment calls in individual cases, which the board and RAD do not get involved in, and policies that the office follows, some of which obviously we'll be discussing in at the commission and in these subcommittees. There's also a high degree of confidentiality regarding individual cases. And in my experience in being on RAD leadership, that meant it was really hard to have meaningful oversight of for RAD over the Office of Chief Trial Counsel. We're looking at enhancing that. So for example, one of the things we've discussed is that OCTC is going to start developing some lists of internal policies that it follows. So those can be discussed with the Regulation and Discipline Commission and may also come to this commission. So that topic is on my mind. I don't think it needs to be on our agenda at the moment, but I want to let you know that work is underway, and we will be reporting to you at some point when it has gelled a little bit more. So with that, if anyone else has any additional topics, feel free. Otherwise, we'll turn to discussing which one of the existing topics we should focus our energies on initially.
I think the E&EC process was mentioned earlier today as a potential topic.
Which I think would be part of settlements. I think we definitely, to my mind, the STIPS and settlements subject matter is important, and E&EC would definitely be part of that. So that's a good point, Steve.
You see Eloise there.
Oh, Eloise.
Thank you. I would suggest some topic that addresses the calibration of the supervising attorneys, the staff that is interpreting the data, that is exercising discretion. I think that this is a really fluid, undefined area, and I haven't heard anything yet. I've heard a lot about metrics and about data gathering, but I have not heard anything about the standards that have resulted in a disproportionate choice to identify solo practitioners or persons of ethnicity and color, or something leads to the identification of certain persons in the legal, the attorney community that are end up in the discipline system. So, but I want to back that down and say, what are the, from the recruitment, going to law schools to make presentations and invite people in who come in as the not having, appeared in court or represented clients or dealt with the difficulties of opposing counsel. From that intake to, the performance of their duties, I would be interested in adding that to our to the things that we're concerned about. Somebody makes a decision.
Sorry, but just an FYI, what I'm going to do is I'll stop sharing my screen and I'm going to be adding all these ideas to the PowerPoint, and then I'll reshare it. Okay. So Eloise, I would love to capture this concisely. So you mentioned calibration team, and then it sounds as though you were going down the road of kind of like,
well, I put out a lot of stuff. Let me just say, if I were going to focus on anyone, it would be the supervising attorneys who are what are their qualifications? What is their experience? And what is the noise to use all of the things that affect our choice making and discretion, that make us sensitive and alert us. I mean, there's always something going on in people's heads that may escape the training. So I think that the training and the standards and the input that is being provided to the supervising attorneys dealing with all of these teams, that's just kind of an area of concern, because I'm a former teacher and administrator, and so I'm always concerned about the curriculum.
Thank you.
Okay, so I think I heard three things. One from Eloise, one is calibration and the exercise of discretion, which is highly related to stipulations and settlements. I'll come back to that in a moment. So those are a good pairing. Then credentials and training of the supervising attorneys. And then you also mentioned bias. I think I heard you mentioned bias, potential bias in your comments. That I think is more in the purview of the other subcommittee on fairness.
Okay.
But if you disagree or others disagree, it's something we can discuss.
No,
That's one of the challenges of these subcommittees is there's not a sharp division between them. And that's one of the reasons I'm going to try to participate in all the meetings of both subcommittees. So that way we don't have things get lost and we don't have both subcommittees working on the same thing. And we've learned from prior groups like this that that's a really important thing to manage. Now, let me also mention, you mentioned,
I'm sorry,
just hang on one second. You mentioned discretion. Another thing that should be on our list, I thought was on the list from last time, is the concern that the defense bar has raised that the Office of Chief Trial Counsel overcharges cases sometimes. In other words, applies more serious labels or allegations to the conduct than is warranted, and in particular in the charging of moral turpitude allegations. And the defense bar will say, and when I did defense cases, I have to say I had some experience too with this, that moral turpitude was overcharged, and that makes it really hard to settle a case because attorneys are often not willing to compromise on moral turpitude if they feel strongly that they didn't engage in conduct that really amounts to moral turpitude. And so I know that Liam, I don't know, or Dag, if you know the status of this, for a long time, we've been planning to gather the statistics on that, but I don't know, which I think would involve comparing charges made in cases that go to trial versus the outcomes. And what's the status of that? Because that's going to be an important part of the discussion about settlements, I think, and discretion.
We've initiated those results, Sean, and we know that this is something that's probably was going to be part of the commission. So we'll have results to share when we take if we take in-depth look into moral turpitude.
That's great. That's great. Because what we have now is anecdotal, and so we want to look at something that's a little more systemic. If we and not scientific, but quantitative would be a better word. Leah's the expert on these things, and Lisa, so you can help me with my vocabulary. All right, so other thoughts?
I see the hands up, Sean. We've got Karen, Linda.
Oh,
yeah.
Okay, Eloise, let me come back to you. So Karen and then Linda.
Just wanted to express an interest in having there be some balance, I guess, to the types of issues that we look at, so that it's not, I mean, I understand there's concerns from the defense bar and concerns from the respondents' view of things, but I think we shouldn't also, should also not lose sight of the fact that we're trying to protect the public. So, are we looking, if we're looking at, I don't know how many issues we're sort of slated to select here, but I just feel like there should be some balance where if we're looking at something that's sort of focused, on the respondents, that we also are looking at stuff like on the prevention side, or on the sort of the public's side, or how does the public feel about how these cases are resolved? And I don't know if we measure that, I don't know if there's metrics around that, but just that there be some balance to what we do so that we're not sort of looking at only one side of the issues. And I personally have a serious interest in seeing the kind of the prevention and the diversion side of it, but that's just my, one person, but it just overall, it seems like it'd be great to have some kind of a balance on the issues that we select, if that's helpful.
Good point. So right now I've jotted down prevention on my short list. We can, and it's all open for discussion. So good points. Thank you. Linda.
I noticed in the most recent state auditor report that there was some question about whether the various structural changes that had been made were really effective. And I guess my thought on that is it might be too new to rate, but I'd be interested in any perspectives of the State Bar, staff about how they view the way the teams are working, and if that is something that they see as being a good way to go, and also on the the morale of the staff, and if the staff has adapted well to the new processes. So question being whether or not we should have any focus on the new structure and how it's working, and if it needs any tweaking at all.
I'll give some, Steve, maybe you can comment, and Leah also was highly involved in the process of forming these new teams. One of the things I can say about the auditor's report, and we talked to legislators about this, is the auditor actually didn't, I don't think, included in the recommendations portion of the report a change in the teams. It might have said that we should study them or look at them. But overall, we did have a different perspective on that topic than the auditor did. And we had a different perspective on how to present some of the statistics in the way that the auditor did. And so there is, I'll say that at a high level, and maybe Steve and or Leah or Lisa would want to put a little more meat on the bones.
Thank you. Yeah, sorry, I wasn't sure if Linda, you were asking for our feedback at some point as a topic or right now. But I agree that I think that the perspective the auditor had was different than ours. I think that what they were coming from was that they expected, based on a prior audit, that the bar was going to do a study and then come up with a recommendation as to what the backlog number should be, to go to the legislature to talk to them about the backlog. And what the bar did was looked at all the processes to see what resources would be needed in order to accomplish various potential backlog goals. And as part of that, and Dag or Lisa or Leah can correct me if I'm wrong, because I wasn't here at the time, but as part of that, they had I think it was the National Association of State Courts or something like that, come in to look at the processes. And they looked at it and said, well, here are some recommendations for efficiency that we would make to change things or to improve things. And ultimately, the issue is that you can't sort of baseline the resources needed or what the backlog statistics should be without making sure that what you're doing is efficient. And yeah, there were some problems because we, for example, as Melanie mentioned, we promoted 11 of our most senior attorneys into supervising attorney positions, and they then didn't carry caseloads that they used to. And we didn't have additional resources to supplement those, right? We didn't hire 11 new people. And so we really impacted the case processing. At the same time, I do think that, and I think it's fair to say we do think that this structure is much more beneficial. We are a much flatter structure. We don't have as many layers of approval and things like that. It does allow us to move more quickly, but it did slow us down initially because we didn't replace those people with resources. But the auditors assessment of that did not look into all those aspects. If that makes sense.
I'm now remembering, I think Leah Donna was an attendee earlier, our interim executive director, but she's not here now. She would know better. I believe they did point out correctly that in 2019, the bar planned to do some kind of formal evaluation of the new structure, and it wasn't done, I'm told, because basically of bandwidth, because we had so many studies and things going on that it just was decided not to pursue it at that time. And so I believe we have committed to carrying out that process. So what I would suggest on this one is, in Lisa and Leah, if you can note this, perhaps for our next meeting, we should have a more fulsome presentation about this topic. But I think the recommendation from the auditor is going to involve another study process. And so it probably doesn't make sense for this commission to dive into that, or this subcommittee to dive into that too deeply. But because I don't have all the facts at hand, we can have a better presentation on that at the next meeting. That would be my recommendation.
I guess one other question I would have is whether staff is satisfied with the metrics and the way they are currently being implemented, and whether or not there is any desire to make changes in the actual metrics themselves. Are they really adequately measuring the efficiency of the process, or should they be changed? Do you have the power to change it? I don't know.
Yeah, let me here again. So I'll start off, and then staff, Stephen especially, feel free to chime in. So the answer to your question is yes, we think they should be changed. The statutory backlog measure, which everybody calls backlog, but it's a very specific statutory definition, which is the number of cases on December 31st of each year, not a rolling average, just on December 31st that are more than 180 days old and haven't either been closed or sent to state bar court. I hope I have that right. If I don't, someone wave frantically at me. So I think there's a consensus that that's not a reasonable metric. It has a lot of problems. And over the years, it created a method of operation in OCTC that was not the best, which was it motivated them to focus solely on closing the oldest cases or moving the oldest cases. And it also caused them to sort of like in the fall every year, everyone would gear up and try to really hit it. And so it's not the best way to run an office. And so that's when Steve, when he was chief trial counsel, came up with the case prioritization system that was talked about last time to categorize each case by level of importance to public protection into P1, P2, P3, and to make sure that the highest priority cases, which involve things like, I think, misappropriation, vulnerable victims like immigrants and seniors and so on, that they get the highest priority. And the office has been very successful. The board approved that, and the office has been successful in implementing that. So for example, last year, the case clearance rate for P1 cases, the highest priority cases, was 146%, much higher than the overall average. And that's what we want to see. We want to see the backlog. And when I think of backlog, I actually think of it just in the plain ordinary English term of it. We don't want a lot of cases backlog. The statutory backlog is just not the most helpful metric. So that's what we want to see, is those priority 1 cases getting the most attention and moving quickly. And then we also want to work long-term on reducing just overall backlog. We are going to, well, the bar has for several years been in discussions with legislative staff about new metrics to replace that statutory backlog as the key metric that people look at. And we now have more sophisticated ideas about that and are already in discussions with ledge staff about that. But the basic concept would be to, and here again, Donna is more expert on this because she's really the point person on it, along with OCTC leadership, is to, Donna has joined us, is one idea is to kind of track cases the way that the trial courts do. And so they put cases into sort of 3 buckets, simple, medium, complex, and they have a different time expectation for disposition of the cases depending on the complexity. So I believe it's 12 months for the simpler cases. I can't remember now. It's probably 18 months or 2 years for medium, and probably 3 years to 4 years for larger, more complex cases. And so we think that would be a metric that's more attuned to reality and will be more useful in providing visibility to the board and to the public and our oversight bodies, the legislature and the Supreme Court. But that has to be done by statute. We do have other metrics that we use and publish in the annual discipline report, so that the board and staff find helpful in monitoring the system. But that statutory backlog measure, which is important to our oversight bodies, must be changed by the legislature. All right, Eloise, you've been patiently waiting.
Thank you very much, Sean. This is a question about a very important mailing that I got from the State Bar, and I'm not quite sure where it came from. My concern that I raised last meeting, and I think it was shared by a couple of you, was for aging attorneys, providing support as distinct from a discipline issue, strictly speaking. But I got a formal opinion that was embedded in the email that I opened up that was about dealing with aging attorneys or attorneys who are suffering cognitive diminishment. And I couldn't tell where that, it was very gratifying, because I thought, well, more than some of us on this committee are sharing that concern, but I didn't know, and maybe Donna or Sean or Doug knows where that formal opinion came from. It seemed to me to include, well, it included case studies and citations to the rules of professional conduct, but it also seemed to me, to include some hypotheticals about an attorney in a large firm that was starting to show cognitive decline and an attorney who was not in a large firm. So I didn't know where that formal opinion came from, what its status is, and it seemed very helpful and responsive to some of our concerns.
Donna, did you want to address that? Great.
The formal opinion.
Oh, you need to be unmuted. Hold on. There you go.
Thank you. It's hard to figure out how you can indicate that you can't be unmuted.
Yes.
So Eloise, thank you for bringing that up. So that was an ethics opinion that was developed by the Committee on Professional Responsibility and Conduct. That ethics opinion has been adopted. And so what you received was the quarterly newsletter, quarterly email that we send to all licensed California attorneys that included that ethics opinion. Since it had been adopted, we wanted to make sure that people were aware of that. It was formally approved for adoption at the last board meeting in May.
Thank you. I knew somebody in the system, and I wanted to say that I missed your presentation last time. I think that we had so many questions that we didn't have a chance to see your PowerPoint. But thank you for that information.
Thank you.
I wonder, Eloise, if your comment kind of ties to Karen's. Karen talked a bit about an interest in prevention, and I think the aging attorney population is one which lends itself to a prevention focus. Yeah. So Lisa, in terms of what you're doing there behind the scenes, maybe clustering those together might make sense.
Thank you, Leah. I feel, not all of us are going to be Ruth Bader Ginsburg, with our brains fully functioning, even if our bodies are, not in tip-top shape. But I do observe this myself in my practice. Not every attorney over 65 is, or whatever age, over 50, however we're going to classify the protected class. Not everybody is functioning at peak detailed. It's usually the memory that's has a few little gaps. But I think that the information in that ethics opinion, thanks Donna, was very helpful. But I wanted to pay attention to Jenna's expertise too, because I think we're dealing here with a medical issue that isn't always, under somebody's control. And people who are having memory loss don't always want to be reminded of that or have it observed. There's a difference between dealing with a family member where we can cover for them and, our love and affection and support, helps us deal with them differently than I think is the situation in professional practice.
If I may speak, this is Jenna.
I would look.
Okay, so, a hand.
Oh, I don't know how to do this. As far as the cognitive deficits, we are using the neuropsychological testing for physicians, and it is effective. And sometimes, of course, there's a lot of pride with the doctors and their licenses, and they don't want to necessarily give those up. So we're having to be creative, but also, compassionate with someone who served the community for 50 years. But it's a difficult issue, but we are finding ourselves doing a lot more testing, especially the neuropsych evaluations, to determine if they are still able to practice or not, at least on the medical side.
And I think that would be a, I like your phrase, creative and compassionate, because, we have attorneys who have been generous. They've done pro bono, they've done, their best job. But how to I don't know how the discipline system can be adjusted or used as a communication outreach to so that attorneys could take advantage of or be encouraged to take advantage of this kind of testing, which is very objective and is not, it's not arbitrary and capricious.
Okay, Ellen Pansky.
I know we already have a full plate, but one other issue that I wanted to just put on the list is the imposition of costs and sanctions. This is a new, what seems to be, have caught some new focus, and the state bar is also interfacing with the legislature now, I think. It is a continuing issue. It also impacts older lawyers, those who've been in practice a long time, perhaps disproportionately. So if we have time, I think that should be on the list.
Okay, Steve.
There we go.
Steve, you have your virtual hand up. Oh, wait,
Yeah,
you were muted.
sorry,
Got it.
I was trying to unmute myself and it didn't seem like it was working, but thanks for your patience. Relevant to the older attorneys and things like that, I would just point out that there are some other state regulatory agencies, some other state attorney regulatory agencies that are looking into retirement with dignity, things like that. And in Florida in particular is one, and there are others, and that may be something that we could certainly explore. Something that we've been thinking about, but we haven't made much progress on.
Someone has a hand up. Judge Wang.
Thank you, Sean. Following up on Stephen and Eloise and Jenna, I agree. Sometimes aging lawyers come into the discipline system, and one of the things I try to look at is whether or not a resignation with charges pending is available. From my experience, unfortunately, is if OCTC wants to pursue discipline, we cannot kind of go that track with kind of with that dignity. And I think this comes up with all industries. I think, as Eloise pointed out, you know, with doctors, we have the same issues, right? If you have a good support system where your friends and your family can tell you, hey, it's time for you to consider retiring from the field. And if a lawyer doesn't have that support system, they end up in our discipline system. And, you know, we're kind of caught in kind of this binary system right now. So that might be something we can take a look at, whether or not the rules for resignation can be relaxed a little bit.
All right, Leah.
I just wanted to respond to Ellen's comment that right now the issue of fees is, and this kind of goes to one of your points earlier, Sean, it has been identified for the Fairness Subcommittee, but we specifically called out this issue of the relationship between fees and settlement. There was a question or a statement made at the last meeting about whether or not the excessive fees kind of push people to settle. And so this group, I think, is going to be looking at settlement. So I do think, again, to your point, Sean, we'll need to make a decision about where certain things are going to be housed. But I did want to let Ellen know right now that's on the PowerPoint for the meeting that starts at 1.
Okay. So maybe that tells us that one of these two groups at least will be looking at that. And to the extent that a topic like costs and penalties addresses both effectiveness and fairness, whichever group handles it, it's just going to not make artificial distinctions, and they'll just look at it from all the relevant policy perspectives. All right, so we have an extensive inventory now, and so we may need to prune a little bit. Here's my suggestion. I think the topic of settlement, stipulations, calibration, discretion is all kind of one big bundle that is really important to talk about. And not just for the benefit of lawyers, because since I've been on the board and when I was in RAB leadership, it's also a systemic issue, right? Because if we have a settlement rate that is too low, and it's not for a good reason, right? If the settlement rate is too low because cases that need to go to trial aren't being settled, then that's what needs to happen. But if a fresh look at it says more cases should be settled, that frees up a lot of resources in the system and will get cases moving faster. It gets a resolution for the complaining witness faster, and so on and so forth. So it's a very important topic, both from the standpoint of lawyers who want to settle and from the standpoint of protecting the public. And it really is pretty core to the whole system. So I think we should definitely put that on our list. Then I think costs and penalties are sort of on hold. The auditor's recommendations about structural changes in OCTC, I wouldn't put that on our list for study right now, but we'll have a presentation at the next meeting to give you more information about that, and you can always reassess at that time. So that leaves us with, and I'm just one person, this is just my suggestion. So then that leaves us with the other items of credentials and training of the supervising attorneys, an important topic, no doubt. Prevention, including the subject of aging, and based on Judge Wang's comments, perhaps looking at the resignation with charges pending process would fall within that. It's related to that. Also kind of a form of settlement in a way, the way that rule works right now, just for the benefit of commission members. When charges are pending or disciplinary investigation is underway about an attorney, he or she is not allowed to resign, right? So that used to be the case that the attorney could choose to resign, and that would be the end of it. That would terminate any disciplinary proceeding. But Supreme Court, I think recently, but it's probably been 15 or 20 years, adopted a rule that says when an investigation is pending or charges are pending, the lawyer cannot simply resign. They have to go through a fairly elaborate process at state bar court that involves agreeing to what I think is pretty similar to a stipulated for discipline. It has to have a statement of facts of what the lawyer did, and probably what the charges are. I just don't remember, but it's an extensive thing. And the goal of it, I think, is that not only is the lawyer taken out of practice because the lawyer has resigned from the bar, but there's a public record of what the lawyer did that was wrong. And there was a sense that it was important to make that public record. And others who know more about that can supplement, but that's the basic topic that Judge Wang was bringing up. Okay, so
Sean, can I share?
so I guess we need, oh, go ahead. Someone was speaking.
Let's say, Sean, can I show my screen? Because I reorganized everything in 3 buckets of
Oh,
topics.
excellent. Yes, please.
Okay.
Because then we might need some feedback from staff on whether this is doable as an initial list of topics.
Okay, so I did it in terms of, okay, so I heard 3 big buckets. One is prevention and recidivism. So this has to do with preventing support, resources, materials, mandated training for solo practitioners, aging attorneys with substance abuse problems. And then here's the question of recidivism. That's from last meeting. Then under case processing, there's topics that are like in general. These are on the left. And then here are the topics related to settlement on the right. And then staffing, supervising attorneys, what type of experience and training they get, and then OCTC staff, moral, sorry, I should delete that, moral, views on the new structure and views on the metrics. Oh, sorry, it was morale, views on new structure and views on metrics. And sorry, there was one more in public satisfaction with outcomes. Oh, I forgot to delete that, OCTC staffing. So is that helpful to maybe go here, Sean? Like to narrow down here, the settlement and.
Well, wait a minute.
Well,
this is the big list that we started with, isn't it? That's on
no,
the screen
I've
now?
been adding, like, as people are talking, I've been adding to the different.
Well, we didn't talk about malpractice insurance today.
Yeah, I think, Lisa, that Sean's saying some of these we would have taken off. I think you just added rather than started over.
Right.
Yeah. So
yeah, what we want is the shorter list that we've kind of come up with, because we may need to do a little more pruning.
Okay, well, okay, terrific. So why don't I just start highlighting like the ones that you want, that we're shorting on?
Okay, good.
This is one of them, right?
Good idea.
So this is one of them, right? The prevention for these 3 groups of people.
Well, I don't know that it's the 3 groups. We talked about aging attorneys today, but maybe we can just have our topic be prevention right now.
Okay.
And then we know, because there were a couple of different ideas generated, and we know that we will address aging attorneys, but we may do other populations as well.
Okay, great.
And there, so the commission knows there has been some work on that basically in a committee of the board. So that we already have some work to bring back to you on that subject. So we have a running start on it, is my point.
Okay. Should we just go ahead and, because today I heard moral turpitude, or that was from last time, but I heard it reinforced during this meeting.
Well, I think it's a subset of settlements.
Okay.
So and I don't really view it as necessarily increased use of stipulations and settlements. I mean, it's to study the settlement process and whether, how it could be improved or whatever. So,
well, I think
we don't want to sort of,
we don't want settlement. We're gonna
settlement. Yeah, exactly.
Okay, so settlement with all of these subtopics underneath it. And this one is like this is a little asterisk because this is the one that fairness is on the fairness.
Yeah.
Should I just remove it from here from now because we know it's on fairness, or should I just keep an asterisk for now?
I'd keep it asterisk.
Okay. Great.
All right, so there under general, it's calibration. I think that's the only one of those 3 that we've talked about today.
Okay. And then here's for staffing. This was brought up today.
I
don't think we talked about morale. So no, so this is just going to be a presentation the whole thing about the structure of OCTC is going to be a presentation at the next meeting, and the subcommittee can discuss it, but I don't think right now it's on the list for study. Because my sense is that I'm not sure we want to get into that, because I think there is going to be a separate process that staff is going to arrange, possibly with an outside entity, to study that. So, but that's what we need Donna to, or whatever staff presents at the next meeting, to bring all the details to us about that.
Okay.
Okay, so that's on the list for presentation, but it's not on the study list right now.
Okay, great. And then the other one we heard today was public satisfaction with outcomes. I think that was, I forget who said that. Karen Bell said that?
Yeah.
Yeah, that's good.
I think for metrics, I would pull it out from like what staff think about it. I know that was Linda's question, and I think that's an important question, but just the broader topic, right, is, are we measuring the right things? And I think what staff thinks about that is important, but what all of you think about it as well is important. So just, I don't know that it's a subtopic of staff reviews.
Okay, so Leah and Lisa, do you feel like you have an answer to the question of what we want to focus on initially?
Okay, so Leah, I heard prevention, and then I heard settlement, and then calibration, this discretion, and then, okay, so this is like a presentation. This is presentation material.
What? Yeah.
No, not the supervising attorney piece. I don't think that's presentation. I think that's something
that was proposed as a topic for study. Yeah.
Okay, great.
I'm thinking that it would perhaps make sense to start with, if at the next meeting we're going to do an overview of the audit and the auditor's recommendations and the work that's going to ensue from there, that we might also want to take up, we could take up additional 2 maybe meaty topics, which would be settlements and also calibration, standardization of our processes. That might be a good thing for us to tackle next. I think settlement in and of itself is going to be quite meaty.
Yes.
And unless Steve or Melanie, you think calibration doesn't relate to settlements at all, but I'm kind of seeing a bit of a nexus there that we could create. So I'm thinking that might be good to focus on in our next meeting.
Well, Melanie's not here. She was here just for the presentation, and then, but she's on the other committee.
Okay.
But yeah, there is some crossover between calibration and settlement.
Okay. And then maybe if it makes sense to bring in at least some information on supervisor training and selection, how it ties to consistency of practices between teams and relates to calibration, we could try to bring that in as well. But I think that would take us to the next meeting, and then perhaps the meeting after that, we can focus on prevention. And that might be a good way to structure things. Does that make sense to you, Sean?
Sure.
Other members of the subcommittee?
Sounds like we have a consensus. All right, everyone. So unless anyone has anything else to raise, I think we are done and you are free to go have lunch.
Great, thank you.
All right, thanks everyone. Look forward to seeing you next time.
All right, bye.
We are adjourned.
Thank you.
Wonderful listeners.